All right. I am so excited to have everybody back with us today. As you all know, my name is Ginger. I'm the Executive Director of Connectionology, and it's just wonderful to be back. We have a lot of webinars coming up this week, so we hope you will join us tomorrow and on Thursday as well. I'll be announcing those topics at the end of this webinar. But you are going to be meeting our amazing partners from HMR, OnPoint, and Fox AE. Also, later on in this webinar, we're going to bring them in so they can share with you all the great things that they do. And I am so excited to have Greg and Rand with us today. And then John Romano is back. He'll be moderating. We want you to ask questions, but hopefully we'll be able to answer a lot of those towards the end of the webinar so we can get through the presentation. If you would like a copy of the slides, I put Greg's email in the chat box, so that way you can reach out to him after the webinar and get a copy of the slides. And then also, we'll be posting this webinar on our YouTube channel, so you can always refer back to it and share it with your colleagues. But in the meantime, let's get started because there's a lot to talk about. I want to introduce our moderator, John Romano, who is also the founder of the Romano Law Group in West Palm Beach. And a neat fact about John is that he was actually a captain in the United States Marine Corps before he became one of America's beloved trial lawyers. And he's also board certified. He's gone to trial in just about every type of civil and criminal case that there is. He was also inducted in the Trial Lawyers Hall of Fame in 2016. And he's not only an author, but he's one of the most sought after speakers in the country. And I am so proud of John Romano because just a week or two ago, he's completed his 50th state. So he spoke in Hawaii and he crossed that off to his bucket list. And I just thought that was a really neat accomplishment. In addition to that, he's also been a past president of the Melvin Belli Society, the National Trial Lawyers, the Florida Justice Association, as well as the Southern Trial Lawyers Association. We all know that at home, John is actually the vice president because he's been married to his beautiful wife, Nancy, for over 52 years. And they also have 11 beautiful grandchildren. So John, I am extremely proud of you. Glad to have you back with us today. And I can't wait to hear what Greg and Rand are going to teach us.
Ginger, thank you so much. And I hope for all of you who are watching this webinar and so many of the others that you either pick up the phone to call Ginger and thank her or send her a text or an email, because when we go back to the initial time COVID got started up, CLE somewhat vanished from the planet for a little while, except for what Ginger was doing initially with Connectionology. And the next thing we knew, there was one webinar a week, then two a week, then three a week. And in all that period of time, Ginger was putting on webinars. And we are now at well over 300 webinars since COVID started. And that is all because of Ginger and her persistence. And Ginger, thank you for what you do for all of us in the world of CLE. And thank you for staying in there and helping so many people. But Ginger is just spectacular. So thank you, Ginger. Maybe we'll have an appearance, by the way, from our mascot today, who is usually nearby Ginger. So we'll see. But I want to tell you, I am thrilled today. We not only have a very, very important topic dealing with tips on how to handle and deal with and relate to with respect to retained expert witnesses. But we have two extraordinary speakers who are seasoned veteran trial lawyers who know and understand litigation, how to try cases, how to take depositions, how to handle all kinds of problems we deal with day in and day out. And there are some lawyers who somewhat watch and observe what happens in the practice of law. And then there are those who do it day in and day out. And that's what we have in Rand and Greg. So let me start, and I'll introduce Rand Nolen, board certified in personal injury trial law by the Texas Board of Legal Specialization, partner in Fleming, Nolen Jez right there in Texas. Has tried some of the cases against some of the largest companies in the world, including Exxon, Wyatt, Pfizer, Ford Motor Company, and many more. And he's gone to verdict in state and federal courts all over the country. I mean, in like 10 or 12 different states. What an extraordinary background he brings to this subject. And with him, we have another just splendid courtroom advocate in Greg Brown, also a trial lawyer with Fleming, Nolen, and Jez. Has handled or is handling cases in trucking, automobile negligence, negligent security, medical malpractice, False Claims Act, mass tort, class action, many other types of litigation. And Greg was previously selected top 40 under 40 with NTL, and also a rising star with Super Lawyers, which is really a terrific organization in terms of the way they go through the selection process. What I love about both of them, though, they are in one of America's premier law firms focusing on the high caliber handling and litigation of major catastrophic injury and death cases. I'm going to turn it over to them as they walk us into this majestic world, I guess I would call it, dealing with expert witnesses. The floor is yours. Rand and Greg, welcome. I'm glad you're here, and I'm looking forward to this.
Hey, John, thank you very much. Thank you, Ginger. Very good to be with you all today, and I'm very glad to be with Rand, Rand and I have worked on a lot of different cases throughout the course of my career. As John mentioned, we have worked on very broad different case areas ranging from medical malpractice, mass tort, products liability, trucking, personal injury. And over time, we've encountered a lot of different kinds of experts. In some cases, we may have just one or two. We recently had an aviation case where we had 7 liability experts and 2 damage related. The last presentation I gave on the PFO litigation, we've retained probably a dozen cardiologists, neurologists. And we've seen a variety of very good experts in these fields. We certainly try to hire good experts in the cases. And a lot of the information today, I think, will be familiar to the experts as well as the lawyers. But, and you know, this topic is pretty broad. So a lot of this stuff today is going to be meant to cover the pretrial process. And if y'all would like to have us back, we would love to talk more about certain trial strategies and other things related to experts. Okay. So let me go through just our agenda. In terms of what we're going to talk about today, we're going to talk about recommended practices to set your experts up for success throughout the pretrial process, starting from the time of disclosure up until the trial itself. Pitfalls to avoid, just certain areas that can really get an expert into some trouble, and we want to avoid that. And then, you know, although some of this information I think will be applicable to experts across the board, there are certain special expert-related issues in certain kind of cases that we're familiar with that we're going to discuss, and then we'll wrap up and answer questions. Okay, so this is a picture it's a video game called Mike Tyson's Punch-Out, and what we're trying to do is avoid our experts taking big hits and punches that will really not only impact their credibility with the jury, but the court. I'm a believer in if you give fodder and you have an expert that gives an opinion that squarely is not going to be admissible, they're going to be more vulnerable to taking bigger hits in terms of their overall methodology, the reliability of their opinions. They're going to be more prone, in other words, to get excluded as if you give fodder and they clearly offer an opinion that's not going to come in. And that's what we want to try to avoid. Again, this is going to be really focused on from the time that they're retained and disclosed, kind of through the pretrial process. And we're going to talk a little bit about trial-related matters. But that's the biggest focus today, is we want to set our experts up for success. And I think a lot of them already will know some of these things to avoid, but this hopefully will be a good reminder.
Hey, Greg, if I can jump in just for a second. The first thing you need to decide is whether you need an expert. And in most cases, you do need an expert. But you've got to decide, do I need an expert? And if so, how good an expert do I need? Do I need the best expert in the world? Am I going to pay the highest dollar I possibly can for the best expert that ever walked the planet? Or would a midline or even a lower line expert do in your particular case? And a lot is dictated by the economics of the case. There's another consideration, and it's a first consideration, at least for me, because after 30 years, I have had the fortune or misfortune of working with novice experts and people who earn a substantial part of their living testifying in litigation, and there is a giant difference. The amount of work and effort that it will require of you working with a new expert or somebody who has very limited experience is entirely different than it is working with a very experienced expert. In Texas for many years and outside of Texas, because this particular expert testified all over, we had an economist who was in El Paso who at one point, I think, testified that he had done 7,000 depositions starting in 1974 and going through really his 90th birthday. He was still active. He was an expert who required no work. You gave him what he required up front, and then he did the rest, including presenting himself for deposition and telling you just to stay home, he would handle it. And I'm serious. Many lawyers in this state and New Mexico and other states did not even attend his depositions because at some point it wasn't really necessary. But if you hire a brand new expert, you will spend a substantial amount of time preparing that expert to testify because they just don't have any understanding of the process or the basics or what it is that they're really there for other than what you tell them, because they just don't have a background and it's not intuitive for them. But either way, the thing that you have to do right up front is determine what it is you want that expert to testify about. And so preparing your disclosure and getting the expert to agree upon the parameters of the disclosure is vitally important. And you will be happy you did that, because it's like a contract between you and the expert as to what it is that expert is going to review, what that expert is going to consider, what that expert is going to testify about. And the expert needs to understand right from the beginning that the case is likely to go to trial, and therefore they need to continually get ready for ultimately testifying in front of the jury. All right, Greg, go ahead.
Thanks, appreciate it. Okay, so a lot of the case law and kind of principles we cite, I recognize, look, Rand and I practice in Texas State Court, and we practice in a variety of federal courts. Of course, there are certain distinctions and differences in jurisdictions, and I think I wrote this down correctly, but somebody can let me know if otherwise. There are certain states that still recognize FRI, including California, Illinois, New York, Pennsylvania, Minnesota, and Washington. I recognize that it's probably certain states that have some subtle differences in their rules. I think generally speaking, the information is applicable and should be followed no matter what jurisdiction, but I do recognize that the case law particularly is going to be federal based and some Texas based, and there may be some differences. And another thing, this is an example, is the burden is on the proponent of expert testimony to show that it's admissible by preponderance of the evidence. And what we're geared at today is trying to give you tools to help meet that. And this is the first recommended practice that Rand was touching on, is to accurately assess the case value, economics, and needs at the outset. Certainly there are cases where it would be great to hire multiple experts, but the economics just don't make sense. I mean, if it's a $20,000, car wreck case, it's probably not practical to hire 5 experts. It just kind of depends on the case, the nature of it, the more complex it is, the jurisdiction you're in. And certainly you want to do the best you can to assess that at the beginning of the case. And look, I totally understand that sometimes things change and you recognize you need an expert when you get deeper into the case. That happens quite often. But trying to determine what you need from the outset is helpful. And there's particular kinds of cases where it's really helpful to get at least, it'll start as a consulting expert and later as a disclosed retained expert very early on for various reasons we're going to talk about. Go ahead, Rand.
Well, I mean, that's the bottom line is that you can overwhelm your bottom line for the case with an expert, because it's not uncommon anymore to see an expert charge $10,000 a day to give testimony and deposition. We see that all the time. We're involved in a case right now with 12 retained experts, and there is a wide spectrum of what those experts believe their time is worth and how much they charge. So you have to assess what your value is for that case, what your anticipated value is for the case. And it may be in some cases that you can get by just utilizing treating doctors, or you can get by utilizing some of the fact witnesses who have a great deal of expertise to make your case. But most cases now, you do need a retained expert to assist you. And so determining from the outset how valuable that expert is to your case and what you're going to pay that expert really does require some advanced planning and a sober thought process, because otherwise you can really swamp your case.
Right. And another thing, let me mention, especially for experts on certain, critical areas like causation, very helpful to, assess your needs at the beginning of the case. If you can, try to get somebody who you anticipate designating, and then kind of continually, send and feed them various documents that are relevant. So you're not rushing at the end to give them a library of things to read and try to form an opinion. Okay, let me go to the next recommended practice here. This is pretty self-explanatory, but you obviously want to master the applicable expert disclosure rules. In Texas state court, you can serve a report at the time disclosures due, or you could have a summary of the opinions that you have to offer a deposition date. And there's certainly differences state to state. The federal rules are governed by Rule 26 of the Federal Rules of Civil Procedure, which has pretty precise requirements, has to have a list of opinions, a list of various facts relied on, this expert CV, the rate of compensation. That's all spelled out pretty clearly in the rule. Another thing is, I will just say that I am a believer in the expert serving a report for a couple of reasons. First of all, there's something that they can refer back to in their deposition. You avoid certain fights about whether the disclosure mentioned they were going to testify in a certain area. And to me, it just looks more impressive that, look, this expert means business, and this expert has put some time and work into this. But understanding, look, as Rand mentioned, sometimes economics, you want to be careful about that, because a report certainly is more expensive. Another thing I'll mention is there are certain jurisdictions that we've encountered that are very strict about it better be in the report nearly word for word, or it's not coming in. If it's not in the report, it doesn't matter if it's in the spirit or an amplification or in the spirit. If it's not there, it's not coming in. And sometimes that can vary a little bit, but we have a number of cases in Utah. We've practiced in Chicago. They tend to be very, in Cook County, State Court, Illinois, they tend to be very strict about it better be on the paper. Sometimes, depending on the court interpreting Rule 26 in federal court, they'll let the opinion come in. Generally speaking, personally, I'm not a fan of big fights over disclosure, whether the opinion was disclosed. And I think it's best to be more detailed to the extent possible. Rand, what do you think?
Well, I think that by having, if you ask your expert to do a report, by having that exercise, it tells you a lot about your expert and how your expert organizes. It crystallizes the thoughts that the expert has early on, and then it gives them sort of a guide to follow through the rest of the case. It allows you to understand fully the strengths and weaknesses of the witness before you get to deposition. The worst thing to do, though, is to find out 2 days, 3 days before the expert is about to testify that you've got big holes or gaps in your case because you do not have critical opinions that may be necessary to meet your burden of proof. By doing a report or sitting down and doing a very detailed disclosure that the expert is a full participant in, where you're going over each area of testimony and you're committing the expert to providing testimony in those areas, will only benefit you and only serve you better later when you get to the time where that expert does actually have to testify.
Okay, this next recommended practice. So let me take a step back. There's a variety of things that we like to do in terms of experts in their reports. There's language about consideration of the totality of the evidence. I think that's a good phrase to use. Personally, I like to have them write out a paragraph of this is what my methodology is to reach my opinions. But really, more importantly, this recommended language to a reasonable degree of scientific, technical, medical, professional certainty and probability is very important. And yes, sometimes there's a lot of experts that are familiar with that and use it already. Some, like Rand touched on, are newer experts that you have to explain why this is necessary. And yeah, they might get cross-examined on it, but the consequences, if they're left to their own devices and they don't know this distinction, and this is meant to be funny, but okay, you might remember when the Boston Celtics won the NBA Finals, Kevin Garnett yells, anything is possible. But especially in federal court, opinions based on possibility, particularly causation opinions, are routinely excluded, and that can sink your whole case. If you have an expert, especially if it's your sole causation expert, and they say, it's possible the driver was speeding and therefore caused the accident, I mean, the whole case can be sunk. And there's a variety of cases, various circuits. We have a Texas case, let's see. We have a Texas case, Third Circuit case, Sixth Circuit case, Ninth Circuit case. I mean, opinions based on possibility routinely get excluded. And yes, it might not seem like a big difference, probability, more reasonable degree of scientific medical certainty and probability versus possibility, but it matters. It matters a lot. Look, there are limited exceptions. There are certain opinions I recognize based on future prognosis or a future surgery in certain jurisdictions, particularly from a treating physician, that a possibility opinion is okay. But for your retained experts, it's much, much safer and better to err on the side of using that language. Go ahead, Rand.
Well, I think that's right. I mean, there are opinions that say there are no magic words and there is no magic language, but there sort of is. And so the expert has to hold opinions to a reasonable medical or scientific certainty or probability, and they need to say that at least some point so that it appears in your record. The jury will not get what that even means, but there are a lot of things that we do as lawyers so that we do protect our record on appeal, many of which will go right over the jury's head because they're not trained in the law. But nevertheless, you still have to jump through those hoops, and it's important anyway to have that discipline with the expert to talk about whether it's a doctor, an engineer, whatever the profession is, that you just can't speculate. You've got to come in, you've got to give opinions that have a basis in fact. I once had an expert in trial literally resort to, well, that's my opinion. And that didn't go over very well, and we had to try to fix some of that. And that particular expert wasn't a very talented testifier. He had said in his deposition at one point, it's because I said so, and I explained ipsa dixit to him. But nevertheless, having a reasonable basis for your testimony, grounded in science, grounded in engineering, grounded in medicine, grounded in something other than just the bare opinion, is very important. It doesn't seem to be very important anymore with respect to thought leaders in some areas. We have that on television and radio, where people get on who have zero qualifications and give all kinds of opinions. But in a court of law, it still matters, it's still important And so it's incumbent upon you to make sure that you pull from that expert exactly what the opinions are and the basis for those opinions.
Right. And let me just say, look, I mean, like clockwork, in most cases, I'm sure many of y'all are used to the Daubert or equivalent expert challenge that is probably in 90% of most civil cases and tort cases, and to the point where it's obnoxious. The most common and just sort of the classic response, at least probably from both sides, but especially the plaintiffs, is the criticisms and arguments go to the weight of the evidence. The problem here is if it's a possibility opinion, they're going to come back with a string cite of binding controlling appellate cases where possibility is excluded, and your court's not going to have much of a choice but to exclude that opinion. And that's why it's really, really critical from our point of view. Okay, next recommended practice, and this pertains to various, car crash, aviation crash, any kind of incident where there, could be, we had a case where the guy had fell off of a lift, and it can be various things where an expert can go see where the incident happened, and we recommend that, and as soon as possible, to the extent possible. Look, sometimes the case comes to you a year or two after the fact, and it's just not possible. But the sooner the better, and for a variety of reasons, they can gather evidence, they can take measurements, they can take photographs. It frankly adds a lot of and bolsters their methodology. Like, I went out to the scene, I was there. And look, sometimes it has to happen a little bit later. It can't happen, the day after or a week after. Sometimes it has to happen a little later. But highly recommend that you have your expert visit the scene, even if it's a year or two. We had an aviation case where the site visit did not happen until 2 years later. Better than nothing. In my view, you provide a lot of fodder saying, I've never been there. I've never even gone out there. And look, sometimes it's not always possible, but to the extent you can, I would have your expert in certain kinds of cases visit the site of where something happened. And just on that note, it also helps, from my point of view, if you're doing an evidence preservation letter, to have your expert review the material in that letter. It could pertain to the site or the product or the car, because sometimes, especially like I practiced for 11 years. I don't know exactly the terminology of what to ask for in every case. Experienced lawyers like Rand or John or Joe Frieders, they know what they're going to ask for in certain cases. In my view, having an expert review and be very technical about what you're asking to preserve is pretty important. Go ahead, Rand.
Well, the other thing that happens when an expert is immersed or involved into the case by going to the scene, going out to where the chemical spill happened, going to the site where there was a crime that occurred, understanding what the layout is, the topography of the surroundings. It becomes very important when the expert takes a stand to try to set the stage and set the scene for what it is that they have found, and getting that expert to talk about what they did other than just sit and review documents is engaging to the jury. It's engaging to have an expert who has demonstratives and props and pictures that they took, and it pulls them in. If you're going to get up and tell a story, the jury needs to understand that you have the tools and equipment to tell that story, that you have an understanding of what you're seeing and you're not just making it up. And so having an expert that's involved in the case beyond, again, just sitting and reviewing documents that you picked for them and you sent to them, it can make quite a big difference.
Okay, let me move on to the next recommended practice. This pertains to product liability cases that are not so much pharmaceutical, but product liability cases based on a product or a device. For Texas, we have in the Civil Practice and Remedies Code a requirement that in a product's case, a safer, feasible alternative design has to be identified as part of the case. Many other states do have that, especially more conservative states have similar statutes or requirements helps very much to have an expert early on identify, and you obviously have to know the requirements of this in your particular state or jurisdiction. In some cases, I've even seen that, you need to plead that, which is kind of amazing to me. But the point being is, although lawyers can certainly do good research and try to identify these kinds of products, if you have an expert in the field, well, let's say it's a medical device, they're going to be able to tell you and line up the requirements of safer, feasible alternative design and have more depth of knowledge of what products are available at that time. Go ahead, Rand.
Well, Greg was just talking about a lift case we handled recently, and in that case, the lift was extended. At some point, the lift falls with the man in it. He falls down. He hurts himself pretty bad when the lift collapses. The expert who went and looked at it had a PhD and very smart guy, and went to the scene, went and looked at the lift in its broken condition. And he came back and he said, yeah, I needed a cotter pin on the bolt that came loose. And so cotter pins, maybe a $2.30 part. And could anybody have seen that? Potentially, a lot of folks who looked at that could have seen it. But the important part is that for whatever reason, the company that manufactured the lift and the company that was charged with maintaining the lift hadn't seen it. And right there, by identifying a bolt with a cotter pin in the end, our expert had identified a safer alternative design. He didn't have to do a lot of testing on it. He didn't have to draw up a schematic. It was fairly apparent, and he was able to show us exactly what he was talking about by simply going to a hardware store.
Right. And that's a good example also. This kind of ties back to the other point is very early on, that particular expert had actually visited the site of the lift, examined it. And, frankly, it's very important to get your preservation letter out early for that reason, so they can go see it as soon as possible. But he did a good job of getting out there and assessing that, and that informed his opinions on the safer, reasonable alternative design. Okay, this next area is a pitfall to avoid. And certainly, I'm not suggesting that your expert can't disagree with or criticize or explain the basis of disagreement or why the other expert's wrong. This pertains, though, to credibility opinions, saying, I don't believe this witness. They're not credible. They're not truthful. The issue is you're going to run into a lot of case law that says the credibility of witnesses, that's not a proper subject for expert testimony. And it might seem like, okay, well, that one little opinion gets excluded. As I touched on, though, the more of these opinions that are clearly going to come out, they're clearly going to be excluded. You're setting yourself up and being more vulnerable for the entire thing to get tossed. Pretty similar, state of mind opinions. The expert offering an opinion of what the defendant or company knew or didn't know, motivation, or just simply summarizing facts without connection to an opinion. Again, a lot of case law that excludes these kinds of different kinds of state of mind opinions, various jurisdictions, various cases, New York, Missouri, 11th Circuit, West Virginia. Certainly, they can testify and offer opinions, including observable facts that are relevant to determining intent. And that's absolutely admissible. But just the purely conclusory they knew or didn't know is going to get you often into trouble. And, there may be jurisdictions where that's admissible and okay, but we found the vast majority of case law that those kinds of opinions get excluded. Rand?
Well, ultimately, the data and information, the evidence that is adduced is there to inform the opinion of the expert. You cannot put an expert on just to simply parrot back what is in a document, what is in a study. They have to identify what's significant about the evidence or significant about the study, significant about the document, and how it informs their opinion, and what they were able to glean from that in particular with regard to the standard of care in an industry, the customs and practice within that industry, and whether or not a company followed those customs and practices. And so they can certainly look at a document that demonstrates that the company was shortcutting something, and that document can inform their opinion about the level of vigilance that the company had with respect to following whatever best practices or guidelines there are. But being able to testify that a company has an evil motive or intent, very difficult to get that kind of testimony in. And you will struggle mightily trying to get that in. And most of the time, you won't be able to get it in. And so if you've set it up from the very beginning where you've told the jury they're going to be hearing from a witness who is going to tell you the company had an evil intent or a bad motive, you're going to have a problem with your evidence, because you may not get that in. Now, you can come back and close an argument, which is a great place for it, and interpret whatever that testimony was and whatever that evidence was and whatever those documents were any way you want. And you can suggest to the jury that it's evidence of evil intent, bad motive. You can characterize your own expert's testimony how you see fit, as long as you think that the jury won't think you're trying to snow them. But getting the expert to do it, very difficult, and sometimes it can backfire on you.
Right. I think you're much better off, for example, saying the expert has reviewed and that 10 incident reports were sent to this company about a similar incident that indicates, or adverse event reports. Then you're connecting it to facts. But the purely conclusory, like Rand was saying, they had evil motives or intents, that's going to run you into a lot of trouble usually, and that's probably going to get excluded. Ginger, do you want to bring in the sponsors? Do you want us to keep going for a little bit?
Yeah, this is a great opportunity, Greg. I would love to bring in Blue first with HMR. We've been working with them for a very long time, and they are just incredible. And it's so good to see Blue back with us again today to share all the great things that they do over at HMR. I can't say enough good things, so I hope everybody watching, either you already know Blue, but if you don't, make sure that you save this information at the end. But Blue, thanks for joining us today.
Thanks for having me, Ginger. Always a pleasure. John, good to see you, my friend. Good to see everything's going well. Rand and Gregory, great talk today. I see this more and more in the industry, where attorneys are, putting more value on these experts and keeping them top of mind and things like that. So this is a great discussion. Glad to be here. So HMR, who are we? HMR, we are the premier funding source for personal injury plaintiff law firms nationwide. We specialize in catastrophic injury cases, traumatic brain injury, spinal cord damage, amputees, the full gambit, right? So I'm going to go through the three things, our three main offerings that we offer for attorneys nationwide. The first of which is going to be pre-settlement funding. So we understand that, this is probably, one of the toughest times, if not the toughest time in your client's life that they're going through, and they're not able to pay their bills, or, they have mortgage payments or child support. I had that one come up a while back. So that's one of the offerings that we provide for your clients. Obviously, it's a case-by-case basis. We'll take a look at the case and go from there. The second thing is directly related to experts, and it is case cost funding. So, like I said, this has become more and more top of mind with all the attorneys that I work with, where they're trying to shore up a case. And to Rand's point earlier, when he brought up the quality of expert, right? So, these experts aren't cheap. they do cost quite a bit of money. It can be a heavy lift at times for law firms. And if it's not a heavy lift, maybe the law firm wants to do something else with that money. They want to use it on marketing or, or anything else really. So that's an opportunity for us to step in and help out with the case cost. So don't let the cost be, keep you out of that realm and keep you from getting the experts and shoring up the case the way you would actually like to do it. So please feel free to reach out to me if you guys have questions on that. I will leave my information at the end here. And last but not least is medical funding. Like I said, we do function in 39 states. So we work with providers nationwide, whatever you need, right? From Chiro to neuro to everything in between. Feel free to reach out. If I can ever help you, would love to do so. And Ginger, thanks again. Appreciate you having us on.
Hey, Blue, thank you so much. That was great job. But I want to thank you on behalf of Connectionology and our firm for all you do at HMR. At our firm, we've been working with you all for many years now. And I tell people all the time, what I love is you all are responsive, extraordinary to work with. But what I like more than anything else is when you come into a case, we ask you to get involved and to fund a case. You go, all right, let's slow down a second. We're going to vet this. We're going to vet that. We're going to vet the client. We're going to vet the case, vet a lawyer, vet a law firm. You take a good hard look at it. Then you come in and you become a part of the team in helping us move the case forward. And that makes all the difference in the world. And so I can't thank you enough. We'll keep working with you. And I certainly encourage others to work with you because what you do for some of these cases is nothing short of working a miracle for these clients. So thank you to HMR.
Thank you, John. I appreciate you.
Thank you, Blue. And don't forget to put your information in the chat box so everybody can stay in touch with you. And then I know Ted is coming at the end for a great coffee giveaway. I can't wait to see who the winner is. And I also want to thank you because I just found out that HMR is coming with us to Texas in September for our deposition skills seminar. More details on all of that for everyone here who's watching today, but very glad that you guys are coming to the seminar. It's gonna be fun.
Ginger, I'm really looking forward to that. We're gonna have a great time per usual. So looking forward to it.
Awesome. Thank you, Blue. And now I see Cody, our dear friend over at Fox AE, is with us. I've missed seeing you, Cody, and I'm glad that you're back and can't wait to hear what you're going to share with us today. So thank you for taking the time to be with us.
Yeah, thanks for having me. And I will be in Fort Worth as well. So I will see all of you guys there, hopefully. Yeah, you too, Blue. I'm going to see, everybody. Hopefully everybody can make it. But yeah, we do graphics. And so right along the lines of what Rand and Greg have been talking about with expert reports and things like that, just a fun fact. A lot of times if we're working with your expert right off the bat, and we get in early before they submit the report of findings, we can actually incorporate a lot of these graphics that we do into the report. And so not only are they harmonious with the opinions of your expert, but they're also within the report. So it's really hard to separate at that point. And so, and Rand and Greg, we've done some cases, and John, it's great to see you, man. And so, yeah, I don't want to take up too much time. I've got some examples, but we can wait till Thursday to show you some of those. But
well, Cody, again, we thank you for all of your support at Fox AE, what you do with Connectionology. It is just tremendous, but we're really enjoying the relationship with you and your wife, Vicki, and your entire team. And what you are doing in the area of medical illustrations, medical animations, liability animations, it is just the best I've ever seen. It is tremendous. And again, it helps so much. You, for example, are an engineer. You have illustrators working with you. master's degree from accredited universities in medical illustration. That makes all the difference in the world, folks. And Cody, what I love, you don't sub these things out. You all are the ones who are doing them. And that makes all the difference in the world. And we have had doctors, we have had experts talk to us about how great it is working with Cody and his team, because they know what they're doing, and it's they themselves who know what's going on. So thank you over and over again for all you do, and we love just working with y'all.
Hey, right back at you, John. And I'm really enjoying this presentation and really love Connectionology. And I hope to see you all in Fort Worth.
You will.
I'm really excited. Thank you so much, Cody. And don't forget to put your information in the chat box too, okay? We will see you back here very soon.
You bet. Thanks, guys.
All right, Greg and Rand, back to you.
Thanks, Ginger. Hey, first of all, we're familiar with HMR On Point and Fox AE. We have great respect and admiration. I'm going to brag on Fox AE and Cody's team. They did an animation for us in a recent aviation case involving a helicopter crash, and it made a huge difference in mediation and throughout the case. And I actually had an expert ask, hey, can I use this animation after the case had finished? So they do terrific work, and as does HMR and On Point. But I just wanted to give kudos to Cody and his team for their efforts in that case.
I just want to follow this up, Greg. Cody, you need to pick up your iPhone and look up the word humility, because with all of this praise that you're getting, I don't want your head to swell up. We got to keep you working with us.
I'm just a little guy.
You are humble. I'm having fun with you.
I'm just a little guy trying to pay the light bill, John.
There you go. All right.
Thanks, guys.
Okay, let me come back to the slide deck. Our next point is just a point of caution. And bearing in mind what Rand said at the beginning, you don't want to over-expert your case. You obviously have to take economics. And look, there are certainly some really good experts that can give opinions in various fields. There's no doubt about that. But I'd be cautious of that, and to make sure that they're capable in each field and subject area they're offering opinions. I jokingly call them Swiss Army knife experts. And I'll raise 2 points. The legal point of view, again, the burden is on the proponent of expert testimony. So you have to meet that burden on each area and a variety of opinions, especially if there's quite a few. The expert can be more vulnerable if they don't have really precise expertise, qualifications, and reliable methodology in each of these fields. So you are exposing your expert to more lines of attack if you try to do them all in one. And I'm really talking about complex cases where you have 3 or 4 different very distinct areas that the expert's offering opinions in. This is a case, this is just an example. This is actually a defense expert, and I recognize plaintiffs have used him, and he might do a great job, but this was a case I worked on as a second-year lawyer with Rand, and I'm not kidding. This is right off the website. Expert, MD, JD, MPH, MS, MBA, CIH, physician, attorney, industrial hygienist, industrial toxicologist, and biomedical engineer. I mean, kudos to this guy, because he must have been in school a long, long time. And look, there are some experts that certainly are very capable in multidisciplinary fields. I'm not suggesting otherwise, but there are some downsides, particularly when Rand took this guy's deposition. Rand would ask the simple questions and he'd ramble for 2 pages. I mean, he's kind of a know-it-all, and that is another downside, is they think they know everything. There are certain cases, certainly it's appropriate to have an expert cover multiple fields and areas, but you want to be cautious when you're talking 3 or 4 or 5 different areas the expert's trying to do it in one-stop shop. You could really leave that expert vulnerable to lines of attack. Go ahead, Rand.
Oh, I just remember that expert, and I had some really insightful follow-up questions. After one 10.5-minute answer, my response was, wow, all that? And I mean, seriously, that was all I could get out of it. And frankly, that's what the jury would get. This gentleman was so comprehensive in his understanding of so many different fields that overlapped each other, that he over answered every question to the point where he obscured his own answer. And that is, if you were presenting that expert as highly qualified and obviously intelligent as the gentleman is, you don't want an expert who steps on his own message. I was reminded of this actually yesterday with an interview that the guy who used to be president did, where he just kept repeating something over and over and over about the Presidential Records Act. And it did not matter that he was disabused of his understanding of the Presidential Records Act by somebody who was considered to be a friendly reporter. He just stuck with it. And so if you were prone to want to believe what he had to say, you would have left that interview believing that the Presidential Records Act had a large bearing on the issues at hand, when in fact it has no bearing on the issues at hand, given what the allegations against him are. This gentleman would have obscured that so badly, whatever his message was, because he gave so much information over so many different areas, over such a broad range of topics, that it was impossible for me, frankly, to remember what I'd even asked him. So just something to be aware of. Having a focused expert will be very beneficial to you and to your client ultimately. Somebody who is very focused on what their role is and what it is that they have to say and why the jury should be listening to them.
Okay, next point, and this is really applicable to this day and age where a lot more things, including depositions of experts, are done via Zoom or similar platform. Some experts are very good. They've already gotten the hang of it. They're used to the screen sharing. They're comfortable. They get set up nicely. But we have encountered experts that are not, frankly, and I don't know if it's they don't take it as seriously or they just are not used to the technology. But we had an expert and it drove us crazy. Very seasoned expert. She, I guess, used her phone or the tablet, and it was like looking up at an awkward angle the whole time. It would be really, frankly, not great to play in front of a jury. Look, and Zoe Little Pages does a great presentation on, absolute advanced techniques for Zoom, and I understand sometimes that's tougher on economics wise or whatever. But certainly make sure your expert has a room or an area where they can appear cleanly, visibly, audibly. I've had an expert, this is the defense expert, where there was a dog barking in the background. This stuff that you see all the time in these Zoom depositions that's unusual. But certainly try to make sure that they're familiar with that. Like, we've been kind of surprised sometimes when there's an experienced expert that just does not look great on the Zoom. And that leads me to another area that's similar. It's great to have a sophisticated and experienced seasoned expert. That helps a lot because they know sort of the traps and the pitfalls to avoid. But I would certainly try, not only, it's one thing to see a list of cases and they clearly have experience. If you can, try to read some of their reports in trial and deposition transcripts, even if they're experienced. And I don't know how Rand will feel about me telling the story. I'm not going to name the expert, but in a medical malpractice case, the expert appeared via Zoom. And in the middle of the deposition, their spouse walked in and she started talking to her spouse. And the spouse said, "Oh yeah, that doctor saved my life." And like, we were floored, like we were emailing each other, like, did that just happen? And this was an expert who had appeared in like 100 cases. You would think that would not happen in this kind of deposition for this seasoned expert, but it did, and I couldn't even believe it. Go ahead, Rand.
Yeah, that was a nightmare.
I mean, again, like, it's great to have experience and be seasoned and sophisticated. It's just you really want to take a look at what their actual work product is in terms of their reports, their deposition and trial testimony, not just simply look that, hey, they've done it before.
Having said that, the expert, when she was giving her actual opinions in the case, did an outstanding job and was very well versed, very well prepared. That one instance, she actually elicited from her spouse that she had saved his life, not that the opposing doctor had. But nevertheless, the way that it came off was unprofessional for her, and it would obviously be something that even if we were going to play her video for the jury, which we're not, but if we were, it would be something that would be excised out of the final cut of the deposition. And there were really no follow-up questions on it, but it was something that was unfortunate and that you don't want to have happen.
Okay, next area of caution. It can be a great thing when you have an expert, depending on the area of medicine or the issue in the case or the product, if they've written about specifically the issue, they may have a long list of published works in their CV or presentations. That can be great. And in fact, it goes to, one of the classic Daubert factors, peer reviewed. But look, sometimes these experts have pages and pages and pages of written published works. It'd be impossible to go through each one of them, but to the extent you can, try, especially on the on-point topics, to try to quickly and the best you can review these works to make sure they're not taking a position that's completely adverse or contrary. And that's, you especially need to be careful on multi-author papers, because sometimes they'll join a paper or a textbook or some sort of work, and it says something that really does not help your case or is expressly the opposite of what you're claiming in the case. Like on our side, when we see the opposing expert do that, it's like happy day. It's a great thing. It's the cross-examination fodder of the century. But I've been on both sides of it, where our expert is on a paper that is completely diametrically opposed to their opinions in the case, and that will hurt. Go ahead, Rand.
Oh, a good expert, though, will be able to distinguish whatever is shoveled up from their past writings. Most of your seasoned experts will be used to some amount of cross-examination based on somebody doing a Google search and seeing a talk they gave, a paper they wrote, something they posted on a hospital or medical website, or even gave at a continuing medical education program. But a lot of them know how to roll with it. It is best for you, though, if you're presenting that expert, to know that potentially is coming, so that you can at least address it with the expert and get them ready to deal with it.
Okay. Next recommended practice, and this is sometimes this happens, sometimes it does not. And look, I recognize there's probably room for substantial disagreement here. In our view, at least my view, let's say the expert disclosures are due, but they have not taken the plaintiff's deposition, and the plaintiff hasn't had occasion to give testimony, or maybe hasn't even given a statement on the incident report. Okay, yes, you do open it up to cross-examination and discovery, but in my view, I think it helps to have your expert interview your client either in person or Zoom, because the downside is especially in a personal injury case, you've never even talked to the plaintiff, you've never met the plaintiff, you're just looking at paper. And yes, they will have to talk about what questions they asked and what they went over with the plaintiff. And I understand, depending on the client, this may not be a good idea for certain types of cases and clients, but to me, the downside of that cross-examination, like you've never even met them, you've never talked to them, you've never done this with them, I believe it helps their methodology, for one. I think it adds to the credibility of their opinions. Certainly, you don't just want to have them as a vehicle just to say, I believe them, like we went over earlier, but I think it helps their overall methodology as part of their investigation, their fact finding, and so forth. I talked to the plaintiff as part of my opinions. Go ahead, Rand.
Well, I think that's right. If it's feasible to do it, then go ahead and do that.
Yeah. Okay, these are some specialized issues. These are more very specific kinds of cases. They may not be applicable to every kind of case, but there's some important lessons to learn in certain types of cases that we wanted to talk about with you. Okay, you might have seen this term. In medical causation cases, there's a term called differential diagnosis, otherwise known as the differential etiology. And this is some of the case law. Generally speaking, if the expert does it correctly, a differential diagnosis is found to be a reliable way of giving a causation opinions. Essentially, there's two steps. Is an expert rules in possible causes of an injury, a condition, a disease, particular in general, and also considering the plaintiff's history. And then step two is there's a process of elimination where they rule out various causes and explain what they're ruling out, leaving one cause, which is, it could be the product or whatever underlying cause of the injury or disease and so forth. Again, in federal courts, it's widespread. If it's done correctly, differential diagnosis and etiology is found to be reliable. What gets physicians, in particular, these medical causation opinions in trouble is when the differential is conclusory. And they say they did a differential, but they really are just honing in on the product or the disease or the injury without explaining how they got there. They're just calling it a differential in name only, but they're not going through that process of elimination with explanation. Go ahead, Rand.
Well, I think that's right. And, you know, that again is the rigor that the expert has to employ with developing their opinions to be able to articulate exactly what it is that they looked at, what they considered, what they discarded because it wasn't plausible for medical reasons, biological plausibility, whatever the case may be, and then what they were left with, and in order to reach their ultimate conclusions.
We're not going to get too much into this today, but essentially there are certain levels of in epidemiology. There's an association with a disease or injury. There's a cause. A lot of the times the way that they can rule out certain things is that it's either a weak association, just temporal. It's not actually established as a cause of an injury or condition, and they can cite literature to do that. But again, the conclusory, well, we know this caused that, with explaining how they got there. And some physicians, most are pretty good, but some of them use that term differential a little differently than what we see in the case law with differential etiology and diagnosis. Okay, Rand, you want to talk about tendering the expert at trial?
Well, this is very highly judge dependent on what level of prove up is required in front of the jury. Greg mentioned Chicago. We've done multiple cases, multiple trials in Chicago, and in one of them, the judge required full prove up outside the presence of the jury, and then required the same prove up in front of the jury, and she wanted a very extensive prove up. And so we spent about 2.5 hours asking essentially the same questions of the expert, having them make the same explanation both in before the jury and outside the presence of the jury. Really, really dependent on who the judge is and how they wish to handle that.
Right. Yeah, so I think, as Rand said, it's pretty court specific. I mean, frankly, it might be even more narrower than local rules. It might just be that particular judge wants it a certain way. And I've seen it, frankly, it seems like the most common practice is it's a formality that's not as required as much anymore. But, you know, I'm certain there are certain judges in courts where you still do need to do it in a formal way. Okay. Next area, and this area has some real gray area, and it could be an area that both experts and lawyers, I don't want to say struggle, but it can be very tough to figure out, you know, a crystal and sharp rule on this. Look, there are certain cases where the experts really have no choice but to use a certain term that may or may not be considered a legal conclusion. That area particularly gets really murky, especially when you have a violation of federal regulations. And there's also certain kinds of cases where they use a term that has a special meaning in the law, and it can be very tough to figure out, is it a legal conclusion, or are they applying an opinion to facts based on a term that an average juror would recognize and know. And this is some of the case law. And this where this collides is Rule 704. An opinion's not an ultimate issue opinion is not objectionable because it embraces the ultimate issue in the case, versus the expert offering a legal conclusion. You see, the case law is that the line, it can be really, really murky. Is it a legal conclusion, or is it simply an admissible opinion about the ultimate issue? I actually think this Fourth Circuit case is somewhat helpful. Well, we identify improper legal conclusions by determining whether the terms used by the witness have a separate, distinct, and specialized meaning in the law different from that present in the vernacular. There's a variety of cases that, even though I think, frankly, that the terms are used in common vernacular, that opinions have been excluded. This is a UCC case in the Sixth Circuit about violations of particular sections of the UCC. You have a fiduciary duty case, you have a deadly force case, an extortion case, a statement about the adequacy of the warning, a violation of the FDCA. And it can be very frustrating because a lot of the surrounding material, for example, the regulatory scheme or the information about the warning itself, those are just concrete facts. But these sort of, I guess, magic words that go the other way, where the courts view that as a legal conclusion. On the other hand, standard of care has found is not an improper legal conclusion. So doctors do use that term, I think, more regularly about standard of care, and that's probably part of the reason why. And then this is a case from the federal circuit where certain legal conclusions, where the testimony concerns state law or a technical provision peculiar to industry. And it can be very dependent on the jurisdiction you're in. This is the federal rule of evidence 704. And again, I recognize that there are certain jurisdictions where that's not the applicable rule. And the advisory note is really not that helpful. It tries to give an example about capacity to make a will. And in some of these, it's just going to be very jurisdiction dependent, and even term by term, is that in or that's out. So we certainly recommend to research the case law to see, is that term allowed or disallowed? But one way or another, especially if it's a regulatory scheme, they should offer an explanation of why that regulatory provision applies and why is that applicable? What are the facts that make it applicable? And look, if you have to tailor their testimony after the fact that they won't use violate this statute or violate that regulation, so be it. But it can be very difficult to ascertain what's going to come in and what's going to come out. Go ahead, Rand.
So I don't believe in just winging it when you put your expert up. And so what I do, and I've always done this, is I write out my questions. And I know what I'm going to ask when I put them up there. I write out direct questions. I try to make it as lean as possible in terms of the sort of nonsense questions that don't get us anywhere. I try to make sure that I have real opportunity for the expert to take a teaching role with the jury, and that there are open-ended questions that will allow them to expand upon their opinions in the case and to opine about the various aspects that they've been retained on. But I am very particular about doing that. So I don't ever wing it, particularly when I have an expert that I've spent thousands and thousands of dollars to bring to a court. I will tell you that there is a very notable expert, very extremely well-credentialed lawyer, doctor, expert, who requires that you write out the questions in advance. He also writes out his answers, and then you practice, because he demands that level of perfection before he takes the stand. And he has been known to decide that he does not wish to testify in cases where a lawyer will not take the time to get him adequately prepared by his estimation, because he doesn't want to get up there and embarrass himself. And rather than being resistant and saying, oh man, what a drag, and this guy's just running up his fee, and gosh, what a waste of my time, and I'm going to have to get out of trial and go over and work with that guy till 12 o'clock at night. What a drag. I don't want to do it. No, you should embrace that. That's an expert who wants to do the very best job he possibly can for you and for your client. You should embrace that. And so I strongly recommend that you take the time to determine exactly what it is that you want to put that person up on the stand to say, and that you're ready to get the best out of that person when they take the stand.
Yeah, and then actually that leads us to our final recommended practice is exactly what Rand said, is retaining an expert who's a strong communicator and teacher. And look, I mean, there's various views about jurors on experts these days, and I'm not going to try to summarize that in the last couple minutes here. And look, certainly qualifications are important. They're part of the evidentiary rules, and having an awesome, resume and being well credentialed, that can be terrific. But really, somebody that knows how to communicate and teach, that's really paramount. And I will tell a story. When I was a second-year lawyer, I referenced this case earlier. We had a mechanical engineer, and the night before he testified, I know for myself, and I think Rand too, we were pretty concerned about his testimony because it was kind of all over the place, kind of blending failure to warn versus design defect. And the defense was all over him about that. And he testified and he did a good job. And after the case settled in the middle of the trial, they liked him the best, and they thought he was relatable. They thought he was likable. And yes, his opinions kind of probably mixed and matched failure to warn versus design defect a little bit. I think it was his first time testifying, but the bottom line is they liked him and they responded well to him. He had good qualifications, but not like out of this world. But he came across to them as somebody who he was relatable, he was likable, and he was trying to get them the information. He didn't go on and on and on. And at the bottom line is he had enough charisma that they responded very well to him. Go ahead, Rand.
Genuine and authentic was what I think they responded to. This was a struggle because it was his first time in an actual trial testifying. And getting him ready to do that was a challenge because he had not put in a lot of work ahead of time. He did after he got to where we were trying the case, and we spent a lot of time with him getting him ready. But when he got up there, he was literally showing that jury he was doing the best he possibly could, trying as hard as he could to answer the questions, to listen to the questions that were being asked, but to couch those answers in such a way where a jury could understand what it was that he was saying. And he used less than super hyper technical language to explain it to the jury. And he looked at them. It was clear that he was trying, and they appreciated the effort, and they related to him.
Yeah, and I'll just add one more just brief kind of story. And Rand has worked with this expert a number of times. I've had occasion to work with him, I think once or twice. He's an epidemiologist named Dr. Nolen Jez. Like, epidemiology, even for attorneys, is challenging. And Rand is a tremendous authority on the subject, but the levels of scientific, studies and the rigor and the different kinds of studies and, association versus causation, on the surface, it's a tough subject. And Dr. Jez explains it in a way that is not intimidating. He breaks it down. He's a good communicator. He gets off the stand, and that's a real art to that. And that's very, very important, I think, especially for complex subjects, to be able to do that. Go ahead, Rand.
No, I think that's right. I mean, that's the power of that particular witness. It would be pretty impossible for somebody to replicate what he has as far as a high ability to testify. But it is the ability to take very complex issues and distill them down. I will say this, and it is very quick. Many years ago, I met an expert who was quite skilled and very knowledgeable in one area of science. I went into the very first meeting with him, and he started writing on a flip chart or a paper flipboard. And he's writing, and he writes all of these equations out, and just one after another. It goes all the way down the page, and then he turns it and he flips it over and he writes more equations, and he says some words, and I don't understand any of it because I'm now just so focused on what it is he's writing there, trying to figure out if I can even ascertain anything that he is saying, and thinking, man, I'm so far over my head. And he says, you know what this is, Rand? And I'm like, all of the equations that show why that chemical compound caused the injuries to these people? He said, well, that's pretty close, but I was going to tell you something else. It's the exact thing I'm not going to tell the jury. And I was dumbfounded by what he was saying. And he said, this is the kind of thing that I would teach if I was teaching advanced chemistry to medical students. And no juror is ever going to be able to get that in the one day that I'm going to be in the courtroom. It's impossible. And if I tried to do this, they would get 0 from my testimony, and that is not why you hired me. So I learned a lot from him. You can be overly technical. You can tell the jury more than they need to know, and more that is useful to them in reaching the opinions of the case. And so, you've heard keep it simple, stupid. Well, you don't have to presume they're stupid, but you do have to understand that this to them is very new. And you may have lived with the case, worked with the case, know all about the case. A guy once told me that I couldn't try a rollover case because it would take me 2 years to understand the mechanics and the physics involved in the rollover event itself. And so I asked him, well, when was the last time you tried a case involving a rollover? And he said 16 years ago. Well, I didn't have 16 years to get ready. And my expert didn't have 16 years to work on the case either. And so we were able to try the case without a 16-year running head start on it. But it's important to remember what you're really trying to accomplish and what the reason to bring that expert is. And that's so that somebody understands what it is that has happened here, not that you've had some sort of esoteric conversation about science or physics or whatever the case may be.
That's right. Okay, Ginger, do we have any questions? Or is this a good time for another sponsor?
Yep. Yeah, we do. We have some great questions coming in, Greg. And Rand, this has been a wonderful presentation. I'm going to give everybody a few more minutes to think of some questions that they would like to ask. And I am going to bring in our final partner for today. Her name is Dawn, and she's with On Point Legal Nurse Consulting. And you guys have also heard us rave about this company. We love working with them, and they do such great work, but they have the most amazing staff and the most experienced nurses. And Dawn has been in this, has it been almost 30 years, Dawn, or more? 30?
Yeah, it's over 30. I'm embarrassed to say, but yes.
No, it is absolutely incredible, you guys. So she knows what she's doing. She's a great resource. And I hope that everyone will also save Dawn's information in a minute. But I'm going to let her take a second to kind of tell you guys a little bit more about what they specialize in, because it's really incredible.
Well, it's nice to see you, Ginger and John. And I've been listening and jotting down notes during the course of this whole presentation. I'm the director of expert witness location for On Point. And before I jump into what I do, I want to talk about our 2 other arms of our company, which are Ingrid manages the geriatric program. So we do an awful lot of work with nursing home attorneys related to falls and wounds and just abuse and neglect in nursing homes, skilled nursing facilities. And we have a whole stable of wound care nurses and geriatricians that can really give you laser focus on those areas. And we also do a lot of behind the scenes work with things like chronologies and timelines and pain and suffering reports. And ours are all done by nurses who are specializing or have specialized in the field similar to your case. So we're not going to put a pediatric nurse on a neuro case. It's going to be somebody experienced in the field when they do it. And they can not only just do bullet points of timelines, events, they can also put a summary and analysis and give you red flags and tell you what does this lab value mean, and really give you insights into things that you're going to need to know with the case. And I'm sure John's going to jump in. So I'm going to just leave the pain and suffering part to him, because I know he always loves to talk about our pain and suffering reports. But what I wanted to talk about from my program, which is the Expert Witness Location Program, are just some of the points that Rand and Greg were talking about. They talked about case value and how that relates to expert cost. And we try and be very respectful of your resources. Even if you have, a $20 million case, we don't want to spend your money needlessly. So we try and be cognizant of that as we're selecting experts. If we're finding experts for you, there's no charge when we locate the expert. If you don't use them, it doesn't cost you anything. So you can always give me a shout, talk about your case. I have more than 30 years of very diverse nursing experience, everything from ER, critical care transport team, to OR and administration. So I can talk with you from a lot of different angles and help make sure that the expert that you pick is the most appropriate expert to use for that particular situation. And we try and find experienced experts, but some of our attorneys say, you know what, they don't really mind working with new experts if they are sharp and smart and really experienced in the field. And one of the nice things about working with OnPoint is we don't just dump an expert on your lap. We'll help them through the process. I can have them send reports to me to proof before they come to you, so that all the burden is not on you. We also can get device inspection reports, which is something that y'all mentioned during your conversation today. And we just recently had a case involving a cardiac device, and the device inspection report was super helpful when we sent the case on to the cardiac surgeon. It gave him additional insight in forming his opinion. And I love the last part of this discussion about, brilliant experts that are either have this imperious attitude or, are just unable to communicate with the jury. And we have attorneys in about 40 states across the country. So some of my Midwest guys will tell me, Dawn, don't send me any of those New York experts because they have a bad attitude. And I don't mean to insult anyone from New York, because I'm in the Northeast myself, but I actually have one expert in New York who is one of my favorites because he's so brilliant, so well credentialed. And he's just so genuinely nice and able to communicate to lay people and really educate a jury, that my Midwest guys are like, oh my gosh, like, I can't believe that he's so amazing. I'm going to use him on future cases. So totally agree with that. And that's something that we're evaluating when we're vetting experts, so that we send you somebody that if you use them as a testifying expert, they're going to be relatable and believable and really help your case. And we're also seeing a lot of plaintiff medical exam requests now, to your point about doing interviews with your client. We used to always hear about defense medical exams, but I'm seeing a lot more plaintiff medical exams, which we are happy to arrange the exam, and then the physician can write a report as well. So we'd love to talk with you about how we could help you with your case, find the best experts, either physician, nurses, ancillary personnel. And I'll post my info and give me a shout, and I'd love to talk with you.
Dawn, thank you very much. That was great. And I thank you for all you and the folks at OnPoint have been doing, and the way you have so strongly supported and helped us at Connectionology Seminars of America. It's just been wonderful. But our law firm has been working with you all at OnPoint now for several years. And I brag everywhere I go in the country about why the legal nurse consultant is so important to the case. And it was interesting, as you were talking, I was thinking back on all of the years of learning when we go to school. What is the most important? And I think most people would agree it's the formative years, where the preschool teacher, the kindergarten teacher, first and second grade teach you how to really read, how to pronounce words, how to add, subtract, multiply, divide, and those become the foundational basis for our entire life in what we are doing. What you all as legal nurse consultants do is you help the lawyers, the clients, the people on the team, and ultimately the judge and jury to understand, to comprehend, to appreciate certain concepts. And you do it because you, more than anybody else, as nurses, go into these records, interview clients, etc. And I tell people, you've got to consider having legal nurse consultants interview your clients, interview key witnesses. You are right. I am going to brag about your pain and suffering reports. Just unbelievable. And I first learned about the concept of these reports from you at On Point, where we take those pain and suffering reports based on an assessment of the records and use them at mediation. We use them in depositions. We provide them to experts who can rely upon them to form a basis of the opinions, and then ultimately at trial. So I can't thank you enough for all you do at On Point, and we will continue to work with you indefinitely. Okay, so thank you.
We appreciate
again.
it.
Okay.
Thanks so much.
Thank you again so much, Dawn, for everything. Be sure to put your information in the chat box for everybody. I'll make sure that everyone watching gets a copy of all of our speakers and all of our partners' information after the webinar. But definitely jot down her information because you'll want to use it at some point. So thank you, Dawn, for being with us.
Thanks, Ginger.
And then John, Greg, and Rand, I do see some questions that are coming in. Would you like to go ahead and take those now?
Sure.
Sure.
All right. One of them is coming from one of our incredible speakers tomorrow, which I will be announcing very soon. But she's asked, why don't you address the need for your experts to memorize the record before testifying to be super prepared? Do you have any thoughts on that?
Yeah,
Go ahead.
that's exactly right. This is also just, and this kind of happened recently, and perhaps there's different schools of thoughts. To me, it's perfectly okay if the expert has their report and disclosure in a med chrono in front of them to refer to. I know there's a lot of brilliant people out there that try to memorize everything, but it drives me a little crazy where they don't have anything in front. They're like, well, I'd have to go back to the medical records. Well, I mean, like, we are here at a deposition. And so I absolutely agree they should be super prepared in terms of the facts. And look, sometimes there's a lot of medical records or a lot of documents, but being prepared is certainly critical. Go ahead, Rand.
No, I think that's right. Although I do think that there are experts who like to testify at trial who feel burdened when they have to have documents in front of them because they will tend to look at them, or they will tend to draw their gaze away from the jury while they're down looking at their notes. Some of them just don't feel comfortable doing that. And so if they can memorize it, if they can know it cold, that's fantastic.
Thank you guys so much. And another question comes in, what is the distinction between fact and expert discovery? If my expert witness needs access to tissue samples in an autopsy case, if we have discovery, the existence of these samples, but have not requested access to the evidence by the expert, can my expert still have access to the tissues for his opinion after the fact that discovery cutoff deadline?
That's a very specific question, and I just don't know. What I would do if I could would be I would go ahead and feed it to the expert, and then because you've got a situation there where if you don't do that, you'll never know what the answer is, and you'll never have an opportunity to argue to the court that it should be not excluded, it should be admissible. And all the court can really do, they're not going to say, well, you've now tainted your expert. What they could do, though, is exclude the opinions related to that examination.
Yeah, I would think it would be better to make the ask and just explain why it's necessary for the expert to take a look at that. I don't know exactly about the timing of certain events in that particular case, but you know, frankly, in and of itself, those slides, yes, I guess they're technically factual, but you know, that area of medicine, I think, implicates expert testimony pretty clearly on its face, but that's a nuanced question, admittedly. Some of it would be in terms of when those were discovered and when people had access to them and deadlines and so forth.
Okay, perfect. Thank you. And then we've got one more question. Is there any value of your expert illustrating in real time in court what the MR or the CT is, especially in spine, and what it actually shows.
Oh, yeah. I mean, I'm a big believer in demonstratives and medical animations, illustrations. I would think that would be very effective. And especially from a teaching point of view, to see that progression and see how that happens. I mean, there's certainly great communicators who can explain it verbally, but to have that visual element, I think that would be very impactful. So, yeah.
Yeah, going back 20 plus years ago, when we did diet drug litigation, echocardiograms were really the central feature of the case in terms of what the echocardiogram showed with respect to heart valve regurgitation. In every case we ever did, we played the actual echocardiogram in court. We had freeze frames that the expert would do in real time, stop, back up, show every aspect of it. When I've done cases involving X-rays of the spine or any kind of radiology, to the extent that we can, we show that to the jury so that they can get an understanding of what it is that the expert is dealing with, what the radiologist saw, what the surgeon saw, what the neurosurgeon saw. You know, I think show and tell is a great way to go. I think it makes it very, very real for the jury. Certainly with respect to the echocardiograms that we were showing, all of that looks like Greek to the average juror. They can't read it, they can't make it out. Well, if you do a good job with your expert, in 1 hour, you can have that jury seeing or believing that they see the actual regurgitant jets that are coming off the valve itself as it slaps shut. And a good expert can do that without being overly technical, but by just stopping, freeze framing, drawing circles around, showing the jury what it is that they're seeing. And that seeing is believing. And then when you close on that, you say, well, the other side asks you not to believe your lying eyes. The expert got up there, he showed you exactly what we're talking about. He told you what it was, or she told you what it is that is the medical significance of what you just saw, and how it's going to affect the plaintiff, my client's life for the rest of their lives, and how that can't be good for them. It's only bad, and it's only going to get worse. And that way the jury can understand clearly, because they've seen it, what it is that your client's dealing with.
Yeah, no, I think that's right. You know, we had a testosterone case a couple of years ago, and this is actually an expert from the defense. And most of the defense experts I thought were okay. Some of them were forgettable. The cardiologist they hired was a challenging expert. And one of the things he did pretty well is he had both the cardiac imaging, and he'd get off the stand and explain things. And he also had the anatomy, like a anatomical model of the heart. And at those points, I think, and to the extent any side can use that, I think it's effective.
Okay, perfect. Thank you guys so much. It looks like that's all the questions we have for now, but I see that Ted has joined us with HMR to come in and tell us who the winner is of their special copy giveaway. And I just wanted to say that if you did not win today, don't worry, there's 2 more chances this week, tomorrow and Thursday, because we have new webinars again at 3 o'clock Eastern time. But Ted, thanks for joining us. It's great to see you again. I know you're here to tell us some good news today, right?
Yeah, it's great to see you all as well. And yeah, I'm really excited. It's Anthony Leone out of Rhode Island. And I think he might be our first winner out of Rhode Island after all these after all these years.
Nice. That's very cool. Well, congratulations, Anthony. We are so happy that you won. Both Ted and myself will be reaching out to you after this webinar to make sure you get this special copy. Ted, I think you've given away thousands of bags of this coffee, but it's been sweeping the nation. I know John Romano still is trying to win some coffee, but John, don't give up, okay?
I won't. I'm hanging in there.
Thank you, Ted, for being with us. Thanks to everything that HMR
Thank
does
you,
for
Ted.
Connectionology and
Thank
for
you.
all of your clients. You guys do great work. We can't wait to see you again very soon in Fort Worth, Texas. And then also I wanted to make another announcement real quickly. that tomorrow we have our webinar with our incredible neurosurgeon. You guys definitely want to watch this. It's going to be really good. And what I love about her is that she makes such a very, it's a hard, a lot of things that they discuss that normally seem hard for someone to understand, but she makes it very easy. And the webinar is so fun. And that's why I love having her and Dustin back with us. So please go onto our website, sign up for this, share it with your colleagues. It's going to be great. And then also, I wanted to just let you guys know that I will be emailing you the contact information for our amazing speakers today and our partners, so that way you can stay in touch with them. We're all about connecting here at Connectionology, you know that. But here's the information so you can stay in touch with Greg and Rand. And also, if you'd like a copy of today's slides, please just send an email over to Greg and he'll make sure that you get a copy. And then again, stay in touch with our great friends over at HMR, On Point, and Fox AE. We are so lucky to work with such good people, and I know that they will be able to help you in a lot of your cases. With that, does anyone have any closing comments for us today?
Thank you a lot.
All right.
Yeah, thank you all
Well,
for
thank
having me.
you. We really
Well,
appreciate it. We hope to see you guys back here
spectacular
soon.
program. Spectacular. You all were just amazing. And I hope we can get you back like right away. What a great duet in the way that you do this and take us into the world of another subject and topic.
Thanks, John.
Yeah,
Thank you.
it's important too. And we can't wait to see you guys in Texas, to come to your home state. We cannot wait. We're looking forward to that. September 14th through 16th. We're coming to Fort Worth. It's a very special program that is limited to only, I think, 60 to 75 people max, because we have 4 speakers: John Romano, Joe Freed, Satch Oliver, Dino Colombo, and you're going to be broken out into groups with them each day. And we're going to have fun events. There's going to be a lot of networking. So this is going to be a very different type of deposition skills seminar, one that you have not seen anywhere else. I promise you, you're going to get a lot out of it. So please consider coming. And we hope to see you soon. Bye, everybody. Have a great day.
Thank you.
Bye-bye.
Thank you.
Thank you.